Hello, everybody, and welcome to this edition of the 12 CEUs of Christmas. I'm Diane Cohen with MacroPro, and I'm joined by Cecilia Lee from the law offices of Stacey Tokunaga. How are you, Cecilia?
I'm doing well. I'm glad it's Friday. Happy Friday, everyone.
Yes, Fridays are very good days for sure, especially if it's a payday Friday. I love those Fridays the best. So how's your holiday season going? How many events have you been to?
Yeah, it's going really well. There's a lot more to come, but so far I've been to 3 events and the holiday season's going on strong. How about you, Dan?
I've been to 4 so far. I think, just one more. So maybe our audience can tell us how many events they've been to. So just type in the question box the number of events that you've been to so far this year. That would be great. I've actually come under the weather, so give me if my voice is a little bit raspy. All right, so let's see. Oh, Jingle. Oh, Emily, I'm so glad that you went to the Jingle Mingle. That's an event that MacroPro holds does in the greater Sacramento area. So, oh, Brandy's had 0 so far, but Kevin's had 1. So let's see, there's others on here, but I'm going to start with the housekeeping. First thing I want to remind everybody, though, is if you were signed up for the acute rehab, well, the Grinch kind of stole that event, and we are taking it back, and it's been rescheduled for next Friday. Everybody that was registered for it will be re-registered for it, and you don't need to do anything about that, but it has been rescheduled. All right, so your certificates will come in Santa speed. It's going to be 1 hour for most of you. Some of you guys have firewalls, and I'm finding based off of the emails I'm getting is that some of the firewalls are taking 2-3 days in order to release that. So if you don't get it, check with your IT department. Otherwise, wait three days and then check to see if you get it then, because it's a firewall issue. The next thing is, if you have any questions at all, you want to make sure that you put them into the question box so I can ask Cecilia those as we go along. And then you want to make sure that you download the handouts now. Please download them. It's impossible for me to send a copy of them to everybody, so please make sure you download them now, as it is attached to the control console. And then lastly, we will have this on the MacroPro YouTube page. So with that, I'm going to wish you a good conference, and I will see you guys shortly.
Thank you, Diane. Before we get started, I do welcome questions because I do like to stay interactive and answer the questions at the time you have the questions. But if you do have any questions pertaining to any of your cases and you'd like a second opinion or some advice, I do ask maybe my email will be at the end of the presentation. You can send me an email instead, because those do take a little bit more time. But if you have any questions about the material, please feel free to use the question box, and Diane will direct those questions to me. Thank you so much, everyone. I hope you enjoy. Okay. So today I'll be presenting on the Labor Code 3600 Affirmative Defenses. As Dan mentioned, I'm from the law offices of Stacey Tokunaga. We are a small boutique firm in Orange County that handles workers' compensation defense and civil defense. So we do handle subrogation matters as well as a lien department. And so we do pride ourselves in aggressive file management and proactive in moving cases forward. If you are interested or you'd like to learn more about our firm, because that's not what we're here about today, right? We're here to learn about affirmative defenses. Please feel free to give me an email or check out our website. Okay, so the very first question that comes up in this subject is, what are affirmative defenses? So if I've had some clients that work in different workers' compensation systems as well in different states. So specifically, this will be geared around California, as I believe most of you, maybe like 99% of you, do California workers' compensation cases. In California, workers' compensation is a no-fault system. So benefits are available regardless of whether an injury was the fault of an employee or the fault of an employer. So even if it was the employee's fault, generally they would be able to still get benefits. But there are some defenses that the defendant can raise in order to potentially not have these cases or these claims be compensable. So we're going to go through those defenses today. The definition of affirmative defense is something that the defendant can assert which gave rise to their injury, such that the workers' compensation benefits should be denied. So in some instances, which we will go over, there may be an injury and it may be work-related, and it would be compensable, but if you raise an affirmative defense, such as intoxication or horseplay, then even though that injury is work-related and can be compensable, that affirmative defense will make the claim not compensable, and there would be no liability for the defendants. And we will go over that in further detail. Okay. The second thing that's really important is how to prove these affirmative defenses, right? So it's the defendant's burden to prove. It's the defendant's burden to bring up these affirmative defenses. So if you don't bring these up, then the judge, the applicant attorney, they won't know that you have this affirmative defense. So I do generally like to tell my clients, when you're doing a denial letter, to put all of the potential denials and affirmative defenses that you will be potentially utilizing in that letter. Even if the discovery is not completed and you need additional discovery, but you think, okay, well, from the employer conducted investigation or from the facts that you have in the case so far, you think that there may be an affirmative defense, I would say put it in the letter so that you can assert it, and then if later on it actually would not meet the requirements for the affirmative defense, that can be done later on. You can always accept a case, but it's hard to accept a case and then try to backtrack and deny a case again, right? So it's better, in my opinion, to deny a case, and then later on, if you pick it up, then you can pick it up. But it's really hard to do the vice versa. Okay. Okay, so the very first defense under Labor Code 3600, I'm not going in order because I like to bring up post-termination first. I think this is the most common defense that most of you will be utilizing. The other ones are not as common. So the first one is Labor Code 3600A10, post-termination, right? So this is when an applicant is not entitled to workers' compensation benefits when the applicant files a claim after they've already been notified that they were terminated, laid off, or voluntarily laid off. So you're going to ask, okay, well, how do I prove this defense, right? So we're going to go through the different types of prerequisites and elements for this defense. Let me make sure. Sorry, I'm still getting used to go to webinar. There we go. Okay, sorry, let me finish up this slide. So when you're asserting a Labor Code 3600A10 post-termination defense, you want to be really careful with the type of notice that was given to the injured worker. So a termination, a layoff, a voluntary layoff all count. But if it's a resignation or if the applicant quit, then those would not be under the post-termination. But this could also go into a gray area because sometimes the employer says, okay, well, I did terminate him. Sometimes they say it quits. It would really be fact dependent on that in that situation. So some things that you would ask is, did the applicant walk off the job? Did the employer send a termination letter? Gave the injured worker, the applicant, the last check? In these gray areas, it'd be a little bit more fact intensive. So when you're doing your initial 90 days investigation and discovery, you want to make sure you get these facts from the employer so that you can assert this defense. And because California is such an applicant favorable state, there are exceptions to this post-termination defense for defendants. So they are listed here on this slide. So if the injured worker can demonstrate by a preponderance of evidence that one of the following of 1 through 4 apply, then the applicant can still get workers' compensation benefits. And before I go over these exceptions, I want to talk about what preponderance of evidence means. So, you know, if you're watching TV or movies, you really hear like beyond a reasonable doubt, like clear and convincing evidence, right? That's the criminal standard. So you see that a lot in TVs and movie shows where the lawyers are arguing court and they say, you know, you need to convict without beyond a reasonable doubt. So that's not what it means here. Beyond reasonable doubt means you have to be 99% certain that this person is guilty or not guilty. But preponderance of evidence is more of a civil. So in civil, it means that 51% that you believe that this person would be entitled to these benefits. But because we work in a such an applicant favorable system, when it's a 50-50 chance in the judge's eyes, then they're most likely going to award the benefits to the applicant. So in that coin toss 50-50, the judge will most likely award it in the applicant's favorable. You're going to have to prove as the defendant's 51%. And generally, judges would prefer to give the applicants the benefits over not, because maybe like in that 50-50, the evidence or the facts are not clear, and so with the favorable system in California, you may not prevail. Okay, so the exceptions for the post-termination are here. The very first one is if the employer was aware of the injury before the notice of termination. And so I think this one's a really common situation that occurs where the insurance carrier, the TPA, want to assert a post-termination defense and then later on find out the employer was actually aware that an injury was reported and the employer just didn't tell the insurance company or the TPA. And so we see a lot of those situations come up. So if the employer was aware, since they are considered a defendant, you would not be able to assert a post-termination defense. Number two, if the medical records contain evidence of the injury, so say if the injured worker went to the doctors, went to the emergency room, urgent care somewhere before that notice of termination or layoff occurred, then they would be able to get workers' compensation benefits, and that post-termination defense would not apply. The date of injury is subsequent to the date of notice, but prior to the effective date of termination layoff. So what this means is it's kind of a little bit of a timing issue here for the third exception. So for example, 60 days between the notice and termination, if you say, okay, well, I'm gonna terminate you in 60 days, and that doesn't occur, you need to do a new notice. Or if in between that 60 days, the applicant does report an injury, then that could be considered compensable. So if the reporting happens prior to that date that they're actually terminated, but after they were notified they're going to be terminated, that would still qualify as not an exception to post-termination. And lastly, the date of injury is subsequent to date of notice of termination or layoff. So usually number 4 applies to CT claims, where generally an injured worker will file a continuous trauma claim for a year period, and it's usually reasonably known or should have known for these CT claims. I do have another presentation on CT claims that I go into more depth about those. So I'm not going to get into it here, but it just means for CT claims, if they knew or reasonably should have known, like, okay, well, I was hurt doing repetitive motions during the job, then potentially the exception of, or sorry, the post-termination would not apply, and it could be an exception. But if you have any questions about that or want to delve deeper into CT claims and how that affects post-termination, then feel free to ask a question, or to feel free to email me and we can talk more about that. Okay, the next affirmative defense we have is a psychiatric injury. I think I skipped this slide. Sorry, I moved my slides around because I wanted to put it. Oh, okay, it's not. Okay, so this is for psychiatric injury exceptions for the I think the post termination as well. Yes. Okay. So so if there's a sudden and extraordinary event of the employment that caused the injury and they filed a claim later on and there's a post termination, then it could potentially be compensable as well. So that's just what that means. Let's see. So these down here, this post-termination exception would apply specifically to psychiatric claims. So you see that number 4 and number 5 is the same as the previous slide, where if the applicant had medical records that existed prior to the notice of the termination, or if they knew or reasonably should have known about the injury before the notice of termination, then that could just get rid of our post-termination defense. Some other requirements to think about when you think about psychiatric injuries when utilizing post-termination is if it was a sudden and extraordinary event of employment. So that could occur, and then if they were terminated and later on come back and say, well, actually there's a specific injury where this occurred and it was a sudden and extraordinary, it may defeat the post-termination defense. Or a finding of sexual or racial harassment by the trier of fact later on, where would still be considered workers' compensation, even if they filed this injury after the termination, just because it's a sexual or racial harassment. So that's an exception to the post-termination. Okay, and for me, looking at the law is great, but I do like to utilize cases when I look at these this black letter law, just so that I can kind of put some facts and kind of help myself remember the law better. So the case I want to talk about is American v. WCAB. It's a 2017 case by the Workers' Compensation Board. So here the applicant bought and wore a back brace for 2 days after their alleged date of injury. So the applicant went and purchased this back brace by themselves. It wasn't given to them by any doctor. And then they were terminated and filed a claim a month after they were terminated. So then the applicant attorney tries to argue that the employer did have notice of this injury because the applicant was wearing a back brace at work, and the coworkers saw and the management saw that this applicant was wearing a back brace. So this went to the trial level, and the judge made a determination and said over-the-counter medication or devices that were self-procured by the applicant prior to termination is not sufficient notice. So the applicant has to tell the someone in a managerial position. A coworker does not count. So someone in a managerial or supervisory position about their injury, or it has to be in their medical records. But just buying a back brace and wearing it would not constitute a report of the injury to the employer. So the post-termination defense was upheld here in this case. The next defense I'd like to talk about is the intoxication defense. You don't really see this one that often, but it is available and does exist if it ever does come out in one of your cases. So the intoxication defense under Labor Code 3600A4 is when an injury is not compensable when caused by intoxication, by alcohol or an unlawful use of a controlled substance. So alcohol or any potential medication, really strong medication or drugs could fall under this defense. So when utilizing this defense, you may say, oh, the applicant, the injured worker, was drinking at work, like got him, right? Like it's not going to be compensable, but that's actually not true. So just because a injured worker is drunk, drinking, or on substances at work does not automatically mean that they're not entitled to workers' compensation benefits, right? No, they are not. So I'm going to go through the requirements or the elements of the intoxication defense. So first off, the defendant must demonstrate that the employee ingested one or more intoxicants. So generally how that works is usually there's they go to the hospital and they get treatment, and there's a blood test that's done, and the levels of alcohol in their system could be present. Or if they're driving and a police officer or a California Highway Patrol pulls them over and does a breath analyzer test, and there's some alcohol in the system or other substances, then the police will most likely make a report, and you can get that information through that as well too. So you must prove that the employee or the injured worker was intoxicated with alcohol or some types of substance. And the very most important part of this defense is that, and the harder thing to prove, besides just making sure that they were actually intoxicated, is there's a cause and effect between the intoxication and the resulting injury. So what that means is, if, for example, the injured worker was sharing a beer with the coworkers after work, and they're sitting around and they get hurt, but it's not due to the alcohol, then potentially the intoxication defense may not apply. So for example, I have one of these cases where this injured worker was sitting after his shift and drinking with some of his coworkers, and there was another worker that clocked out like an hour later, and they were working with a power saw, and then the saw malfunctioned somehow, and the saw piece flew off and cut part of the injured worker's ear. And so the intoxication defense would not work there, because the applicant, even if they're just sitting over there and they weren't drinking, would have still gotten hurt from the saw piece. So there's no cause and effect relationship between him drinking with the coworkers while another employee is over there working, and then this saw malfunctioned and it hit the injured worker in the ear. So that would be, if you take that to trial, it'd be really difficult. We would not prevail on that type of case with those fact patterns. And then just looking at some other cases for intoxication, because I think this is quite an interesting defense, and there's a lot of case law around it as well. The first case we're going to talk about is the City of Foster versus WCAB 2013 case. This is a death case where the applicant accidentally had a Vicodin overdose. And so here there was proof that the applicant had a substance in his body, the Vicodin, after the autopsy was completed. So here would there be an intoxication defense? Unfortunately not, because the employer or the defendant must prove that the employee's use of the specific substances was unlawful. So here the applicant had a prescription for the Vicodin by the doctor, and he was allowed to take Vicodin. So it wasn't illegal for the applicant to take this Vicodin. So improper or negligent use is not an illegal use, right? So just because the applicant accidentally didn't overdose on the Vicodin doesn't mean that you can apply the intoxication defense because he was legally prescribed that medication by a doctor. So unfortunately, no intoxication defense there. The second case I want to talk about is Mintz v. WCAB. This is an older case, but still relevant, and it just shows when you can use an intoxication defense. So here, the applicant was involved in a work-related car accident with an alcohol level of 0.21. Just reminding everyone that the legal limit is 0.08. So the applicant did have a high blood alcohol level in this case. And so the defendants tried to bring up an intoxication defense, and they were successful in this case because of the blood alcohol level from the breathalyzer from the police and the police report, as well as witnesses testifying that the employee consumed alcohol at lunch, and there was testimony that the applicant was driving in erratic behavior before the accident. So we didn't, this was a really strong case because you had both the blood alcohol level and witnesses, but testifying to the fact that the applicant was driving erratically and was intoxicated. Oh, and just to go back to the intoxication slide, I do have another case that I didn't put down here about intoxication. Generally, and you probably had experience with this, the boards and judges, they're all different. So when you're preparing cases to go to trial, to prepare like in front of a judge, sometimes different judges may make different determinations depending on the situation, the region, and just themselves as a judge. So I have another case here that I want to talk about briefly before we move on. In this case, there was an applicant that had a 0.04 blood alcohol level, so they were under the legal limit to drive. And the board determined that there was no intoxication defense in this case because the officer who pulled him over did not spend enough time to determine whether they were intoxicated or not, and whether that intoxication caused injury. So yes, the applicant did have alcohol in the system, 0.04, but the cause and effect that we were talking about earlier, where the judge determined the officer didn't spend enough time with the applicant in order to determine whether that alcohol of 0.04 actually caused the accident or not. So even though there was the testing, and even in a situation where a coworker saw him drink 2 beers at lunch, ultimately the decision was there was no cause and effect to the drinking that caused the accident. And so it's similar to this Mintz case, but there was a different outcome. It was different board and just slightly different facts here. And so again, I like to say that facts and the investigation and just is very fact intensive when it comes to these cases and when you're thinking about taking these cases to trial. Okay, the next case I want to talk about, or the next defense I want to talk about is Labor Code 3600A5, intentional self-infliction. So this is not a very common defense either, but I do like to touch over these just because if you do have a situation when it comes up, this is a really good one too, I think. Applicant has intentionally self-inflicted injuries, right? So you're thinking common sense, if an applicant intentionally hurts themselves, they should not be entitled to workers' compensation benefits, right? So what's really important behind this defense is the intent of the worker. And generally this is kind of hard to prove. You have to prove the injured worker took steps to deliberately and intentionally harm themselves on purpose. So really, how do you prove that they did this on purpose and they hurt themselves, right? So that could come through video cameras, surveillance. It can come through witness testimonies. If I've had some cases where there were death cases, and if you're familiar with them, for death cases they have a certain minimum requirement for payouts for the dependents. So there we did hire an expert to reconstruct the accident to see if this was intentional or an accidental accident. So there are ways that you can prove that there was an intent that they harmed themselves instead of it being intentionally harmed themselves instead of it being just an accident or negligent on their part, because negligent is still would not fall under this defense. So again, I like to go over some cases. For the first case I want to talk about is Fox Sports WCAB in 2023, a very recent case. So here the applicant fell from a 5th floor stairwell with a 42-inch safety railing. The applicant, after suffering this injury, was unable to talk, eat, walk, or care for themselves. And here the defendants tried to bring up a self-infliction defense and say no one in their right mind would hurl them, would accidentally fall off of a 5th floor stairwell. It had to be intentional. they had to flung themselves off of that stairwell, right? And you're thinking, okay, well, that makes sense. Unfortunately, the judge here did not find that there was a self-infliction defense. The reasoning for this is because the defendant was unable to prove that the applicant deliberately threw themselves over the railing with an intent to cause injury. So there is no cameras, there's no witnesses. The defendant tried to argue there's a 42-inch safety railing, and there is no way that you can get over this railing without intentionally doing it. Unfortunately, the board, in this case, 50-50 coin toss, decided to award benefits to the applicant and say that there's no self-infliction defense. So unfortunately, the defendants did not win in this case. The judge here, just a note, the judge here said, even if the applicant partially climbed over the safety railing, there was no evidence that it was a deliberate fall. So here, maybe the defense side of me coming out, but I do not see how this could not have been a self-infliction defense, but the judge made their decision on this case. So the next case I want to talk about is Hapsegi versus WCAB, 2014 case. The applicant here claimed injury when they were struck by a bundle of falling paper and was unconscious for 30 minutes. So here, the self-infliction defense was proven by the defendants. So here, the employer had surveillance videos showing the incident that occurred, and they had the coworker statement to impeach the applicant's testimony. So in this fact pattern, the applicant claimed that the bundle of paper hit them and they were unconscious for 30 minutes. But actually, in this case, the applicant pushed the bundle of paper on themselves and they were actually not unconscious at all. So, and then they just walked by and then told a coworker what happened, but the coworker saw, so it ended up being the credibility of the applicant was in question because of the surveillance video and the coworkers, and the situation not actually happening how the applicant said it did. They pushed the bundle of paper on themselves and fell to the floor. So here the self-infliction defense was proven through the surveillance videos and the coworkers. Okay, the next defense we have is Labor Code 3600A6, the suicide defense. This doesn't come up often, but this is the elements if you ever do come across a case like this. So the applicant has to willfully and deliberately cause their own death. And the exception here is if the suicide is irresistible or uncontrollable impulse resulting from the injury. And so generally with these types of defenses, as the applicant it has passed away, generally the board and the defendants will rely on expert medical opinion to determine industrial causation. So kind of that case, kind of what I was talking about earlier, where we hire in expert medical opinions, we hire in accident reconstruction experts and other types of experts to see that if, for example, an applicant has stab wounds, and they can see from the trajectory of how that goes in, whether it was self-inflicted or whether it was by someone else. So we can hire certain types of experts in order to help us in proving this defense. So here again, I mentioned, since California is a applicant favorable state, when there's a legitimate doubt or evidence is not definitive, then the WCAB or the judge will find the death accidental, which would result in compensability of the claim. Here, like I said, you have to rely on third-party expert opinions and potential testimony from the applicant's dependents, as the applicant is not able to testify themselves. So it's a little bit more difficult in terms of proving. We did have a case at my office, and I don't want it, it's a little gruesome, but an applicant stabbed themselves 14, 15 times. the applicant attorney tried to say that it was work related because they were so stressed at work from the claim and from the situation, and that they need surgery and there's so much going on and they're just so depressed. And so my colleague took that one to trial and said there was and asserted the suicide defense and said there's no way that this was not willful and deliberate. Applicant attorney tried to bring up the exception as well. We ended up prevailing at trial in that case after bringing in multiple experts to show, like I mentioned, the trajectory or of the knife and other testimony that the applicant was not depressed. So my firm has had experience in prevailing on a suicide defense before. If you're interested or want to talk more about it, let me know, but I don't want to take up too much time. Okay. The next defense I would like to talk about is the Labor Code 3600A7, the aggressor defense. You may see this more commonly among among the situations if co-workers or injured workers are fighting with each other at work, and an injury occurs because they're fighting, then this defense could come into play. So the injury arises out of an altercation where the injured worker is the initial physical aggressor. So the person who starts the fight would not be able to get workers' compensation benefits. And so the biggest question here is, who started the fight? When does the fight actually start, right? So words and intimidation is not enough. So if you have two employees and one's squaring up the other and throwing profanity at the other person, that is actually not enough to be the initial aggressor. It's going to have to be some type of contact. It doesn't mean that they have to punch them or hit them. It could be spitting. It could be even like a tap, like if I'm just tapping someone on the shoulder or pushing them. It could be something as minimal contact as something like that. It does not have to be a punch or a slap or anything that is that major. Spitting or a tap would count. So some things to look at when if you do come across a situation where you're deciding, can we bring up this defense? Are they the initial aggressor or are they the other person that they got into the fight with? Okay. The next defense is Labor Code 3600A8. This is the crime defense. So this is when the injury was caused by the injured worker during the commission of a felony or a crime which is punishable as specified as Section 17 of Penal Code. Okay, so what does that mean, right? So under the Section 17 of Penal Code, that's mostly different types of misdemeanors, and they're generally have about 6 months of jail time. So oh no, sorry, this is screen sharing is now paused. Can you still see your screen? I think everyone can, if for some reason you still can't see my screen, let me know, because it said it was paused for a bit. Okay, so here the Section 17 of the Penal Code are different types of misdemeanors that would be categorized as up to 6 months of jail time. So there's different types of misdemeanors here where you'd have to classify. If it's a felony, great, maybe you can assert the crime defense. If it's a misdemeanor, it has to fall under these types of this Section 17 of having at least 6 months of jail time. So I don't want to get too into specifics there, but if you did have something like that and you wanted someone to take a look, then please let me know. So for this, when an injured worker is hurt during committing a criminal activity or act, then they could potentially not receive workers' compensation benefits. However, it's really important to note that the injured worker has to be convicted. So an arrest, a charge, an arraignment leading up to that trial, it would not count. It has to be a conviction in order for this crime defense to apply. Okay, so here, Valenzuela versus WCAB, 1993. It's an older case, but it still applies. It's still good decision, still good authority from the board. Here, the employee, and I don't know why they did this. I don't know what they were thinking, but this employee ran out of gas and stole a truck from some house or some neighbor that they saw. So they ran out of gas in a town, and they went, instead of maybe going to a gas station and getting that little like red gas like, you know, portable fill up, or getting a tow, they decided to go to someone's house in that town and try to steal this person's truck. So then the truck owner who's in the house sees this injured worker or this applicant trying to steal this truck, and goes out and punches this applicant in the eye. And so they try to file for workers' compensation benefits. And here the crime defense was asserted by the defendants, and it was proven because the judge said there was no way that they could see an employer authorizing a behavior like this, where if you run out of gas, you should go steal someone's truck in order to finish your job, right? So the applicant here was saying, oh, well, I was just so scared I wouldn't be able to finish the job in time. I just didn't know what else to do. So apparently he went to go steal a truck. So do not do that. And so, yeah, even though the applicant's actions were the purpose of getting that truck back to the employer and finishing the job, the board said no, they were engaged in a criminal activity, and this was a departure from their job, and stealing is not should not be part of what the employer is going to want you to do. Okay, the next defense is Labor Code 3600A9, an off-duty activity. So this means that the applicant or the injured worker is not working at the time. So what does that mean, right? Voluntary participation in an off-duty recreational, social, or athletic activity does not constitute part of the employee's work-related duties. So for example, if you were to get together with your coworkers for a drink after work and you get hurt in that process, most likely the defendants will be asserting this off-duty activity defense. But then there's exceptions, right? So if this activity is expressly or implied to be required by the employer, such as, for example, if my boss told me, oh yeah, like it'd be really great if you can come to this client dinner, or it'd be really great if you did this for me and had some control over the activity, then potentially this off-duty activity defense would not apply. We're going to go into some other cases to kind of see what types of facts and what the board would determine is an off-duty activity or not in the next slide. But to finish up this one, if the employer used indirect means of coercion to encourage the participation in activity, then the injury would be compensable. So coercion, or expressly or implying that this is a required activity, you would not be able to use this defense. And so here, the elements for this requirement, reasonable expectancy requirement. So what does that mean, right? So it's whether that employee or injured worker subjectively believed. So it's really key here, subjectively believed that this participation in activity is expected by the employer. So it could be everyone else around you could say, oh, well, no, it wasn't required. It wasn't required. But if that employee believed that it was required, that meets the first requirement of this test, right? So but the second prong is actually harder to prove, whether the belief was objectively reasonable. So that's where that reasonable person standard comes in. Okay, everyone around you is saying, no, it wasn't required. It was voluntarily. So the judge in assessing these cases will take a look at that. One, whether the employee did believe that this was that they had to participate and this was expected by the employer. And the second part, which is what we defendants really want and love, in asserting this defense is whether that belief was objectively reasonable, right? Okay, so a case that I'd want to talk about is ESE versus WCAB. Here, there was a law clerk that was working for a firm, and there was a company softball game that was being sponsored by the law firm. And the employer provided the equipment, provided the snacks, provided the times to practice, and there was a minimum requirement of 3 females that were needed or 3 women that were needed in order to participate in the softball league. If not, 4 female players needed to meet this requirement. So they needed 4, or else they would have had to forfeit the game. So the attorney here drafted the law clerk to try to go play softball. So the law clerk ended up going to play softball, and then the law clerk got hurt in this while they were in the game. And so here they tried to bring up the defense of off-duty activity to say that, well, no, this is a voluntary activity. It should not be compensable, right? Because so the WCAB actually said no. This was reasonably expected that the law clerk had to participate in the game because the law clerk thought that she had to since the attorney was asking her to. The judge said, well, she's vulnerable because the law clerk is very low on the totem pole when it comes to a work environment and in a law firm. And if you're a partner or senior attorney, supervising attorneys asking them and saying, oh, we really, really need female employees to play, and we're going to be able to forfeit if you don't join us, and pressuring them, the judge said, yes, this was not a no, this defense does not apply, and this was not a voluntary activity. Okay. The next type of defense, this one also really common among when we're working in workers' compensation, the statute of limitations defense. This is really difficult to upheld. I'm so sorry. My lights are motion activated. Okay, sorry about that. The statute of limitations defense, it's commonly used among insurance companies, the TBAs, defendants, but usually this is a really hard defense in order to prove. So generally, what it means is the period to file a case from the injury date is 1 year from that date of injury. So it's when the applicant should have known or reasonably should have known about the injury. So here, if there's a specific injury that occurred and they reported it, that's not enough. You need to actually file an application with the board in order to make this, in order to have your case and not have the statute of limitations defense be asserted, right? But it gets really tricky here when CT claims happen, and we talked about this briefly before. So CT claims, they could say, well, I was doing repetitive motions, I was injured at work, and I didn't know it was a work injury until a doctor told me, until like a family member, and I got a lawyer and they consulted them. They said it could be a work injury, right? We've all had those types of cases where they said they didn't know that it was a work injury until they retired, went on vacation, and magically the pain went away. So those types of cases, it's really difficult to prove that statute of limitations in that situation for CT claims specifically. So, let's see. And like I said, I do have a CT claim plus statute of limitations PowerPoint as well. Perhaps maybe in my next webinar, I can share that with you guys. So we are done with the Labor Code 3600 affirmative defenses. I do have a couple more. I think I have about like 10 minutes left, but I'm going to go through really quickly just because I think these are quite interesting. There's the horseplay doctrine or defense that you can bring up, where if employees at work or injured workers are just messing around at work and or tricking each other and playing practical jokes, that would not be able to be considered compensable under the workers' compensation system unless the employer knew that this was customary to happen and that they were always messing around, always playing tricks on each other, and the employer never did anything about it. Then the injury could be compensable. And then the minor acts of horseplay, maybe if I'm just like shoving like a coworker playfully and they accidentally trip and they fall, the person who I've shoved would be able to receive workers' compensation benefits because they were not acting or participating in the horseplay. It was just me pushing them and they accidentally fell. I have a very funny slide here that I want to show you that kind of proves my point. So for anyone who watches The Office, you may know the situation or the between Dwight and Jim. So here in this scene, Jim here is putting up a pencil barrier and Dwight's saying, you can't do that. And he says, why not? And he said, it's a safety violation. I could fall and pierce an organ, right? So here, Jim is the employee engaging in horseplay. So if Jim were to accidentally fall on these pencils and hurt himself, he would not be able to get workers' compensation benefits because he's the one participating in this horseplay and putting up this pencil wall. Dwight, who's the non-participating employee, and telling Jim, hey, this is a safety violation. I could fall. I could hurt myself. If he actually does fall and hurt himself, he would be able to get workers' compensation benefits because he was not participating in this horseplay. It was all Jim. Dwight was actually telling him it's not allowed, right? So that's kind of what that would look like for the horseplay defense. I do have a case here. You can look at it later on in your pamphlet. It's kind of similar to what we just talked about with Dwight and Jim in The Office. And I just want to touch briefly on the going and coming rule. So this is a very litigious area for workers' compensation and with a lot of like cases that have occurred. So usually when an employee is coming and going to work, if I'm just commuting in the morning to work, commuting home, if I get into an accident or if I have an altercation with someone on the road, that would not be considered workers' compensation related. However, there are exceptions to this rule. So as I mentioned, if my boss sent me on a business trip, or if I had to go to pick up supplies or went to a client dinner, then those in me being directed by my boss or by the employer, that could be considered compensable because that's no longer just me commuting from work or going to lunch, but the employer directing me to do something for the benefit of the employer. So as I mentioned, there are, like I said, there's exceptions to the going and coming rule. I do have some examples of the exceptions here. This is not all inclusive of all the types of exceptions, or just some of them that are quite common. So like I mentioned, traveling for the employer, if your job is just to travel only, if they send me on a special mission, like if my boss told me to, oh, you have to go to the store and grab these items because we're having a lunch right now and you really need these things for the client, something like that. Something like that where, I don't know why it did that. Maybe because I'm out of time. Okay. Okay. And then these are just some cases for the going and coming rule. I did have like brief summaries here about each one and how these apply and whether it would fall under the exception of the going and coming rule. Unfortunately, I don't have enough time to go over these, but if you wanted to know more, you can always look these cases up on Sullivan, or you can email me and ask about these cases, because this going and coming rule and the exceptions that apply are very fact intensive and could also vary between jurisdictions. For example, I handle a lot of agricultural cases in Northern California. And so when the agricultural workers carpool to work, that could, and if they get into an accident, that actually could fall under the exception. Even though they're commuting to work, it's so common up there that agricultural workers will carpool to work because they live here in this town and the field is an hour or 2 hours away. So they're carpooling, and it's a benefit of the employer. So I do have some cases like that where it falls under the exception. It would be considered workers' compensation related and be compensable. So it really is fact intensive, like I said, and depends potentially on the jurisdiction, because different jurisdictions may have seen like a lot of different types of cases. For example, Northern California, Fresno, with a lot of agricultural workers. So that's all the material I have today. I do want to thank you so much for coming. Some things I want to leave everyone with is that 90-day, really important to do that the investigation with the employers to make sure that you're getting all the information in order to make a good determination for your for the case and the determination for compensability. And it's just really important to do important discovery when it's coming to these types of defenses, because that discovery will really help you in improving your case if you are able to assert these defenses. Thank you, everyone.
Thank you, Cecilia, so much. We didn't have any questions, but I did want to remind everybody this is your last chance to download the handouts, and they are here at the bottom of the control console. It'll say handouts 1 of 5. So make sure that you download those. Until next week, when we have our other webinars. We'd like to wish you a great weekend. I want to pull up the list real quick and let you know what's coming up. So next week we have coming up an aging workforce. If you've ever seen her, you know Angie is also a fantastic presenter. Then we have orthopedics and prosthetics. Those are always interesting to read about and to see and to learn how they really help these injured workers out. And then reopening new and future benefits. So these are some of the topics we'll be covering next week. Until next week, we will talk to you later. Again, thank you, Cecilia, very much for the presentation. And everyone have a safe holiday or weekend. Bye-bye now.
Thank you.